Abre a cortina do passado, tira a mãe preta do cerrado, bota o recôncavo no concado, Brasil, caminho.
Oye, sí.
Bien, buenos días a todos y todas. Vamos a arrancar nuestro último día de esta fase académica del Congreso que estamos celebrando en Río de Janeiro. Y para ello vamos a iniciar esta jornada con el panel titulado ¿Estás listo para asesorar sobre data privacy? Es un tema de particular actualidad y para ello contamos con un panel de expertos que nos van a compartir su visión desde el punto de vista de la experiencia, de los temas normativos, precisamente compartirnos a la vez cuál es esa visión que se tiene sobre la práctica del tema en datos y particularmente vamos a recibir consejos sobre qué es lo que como profesionales del derecho tenemos que manejar, entender y hacia dónde enfocar nuestra formación para poder asesorar a nuestros clientes en esta materia que ha cobrado una especial relevancia. Para ello, contamos con la moderación de Juanita Acosta. Juanita es socia del equipo de propiedad intelectual y tecnología de Denton, Cárdenas y Cárdenas, Colombia. Ella ha trabajado en estos temas también con nuestra organización de forma muy activa y ha liderado una buena parte la discusión que sobre estos temas hemos llevado a nivel de ASIP. Cuenta con más de 25 años de experiencia en el manejo de asuntos relacionados a la propiedad intelectual y, como anticipamos, ha estado profundamente involucrada con los temas de privacidad, protección al consumidor y también asuntos regulatorios como los publicitarios. Participa regularmente en el diseño de estrategias de marketing para comunicación al público y litigios relacionados con estos temas en los que ella está involucrada. Generalmente también está trabajando en la revisión y en la elaboración de términos y condiciones relacionados con los temas de protección al consumidor y comercio electrónico. Ella cuenta con una experiencia muy amplia en el manejo de portafolios de propiedad intelectual con compañías multinacionales y locales y ha asesorado a clientes en esas áreas y en litigios relacionados, como habíamos ya también indicado, al área de la protección al consumidor, el diseño y negociación de contratos, acuerdos de distribución, de patrocinio, licencias, privacidad, protección al consumidor y tecnología de la información. Con Juanita seguramente vamos a tener una moderación que nos va a permitir llevar de la mano el desarrollo de este panel tocando temas claves en esta materia que seguramente nos van a ilustrar el camino a seguir en la actualización del tema de data privacy. Con ella estarán Rodrigo Acevedo, Dirceo Pereira de Santa Rosa y Raymond Gain, y Juanita los presentará oportunamente. Adelante, Juanita.
Gracias, Marco. Agradezco mucho, les agradezco a todos haber. Realmente hoy que muy afortunados con un panel de primera categoría. We're going to try to keep this panel conversational, so I think that we're all going to speak English today. So we get started. The name of our panel is, Are You Ready to Counsel in Data Privacy? So when our experts were asked this question, a number of answers came. Two of them basically. Are we ready as law office to counsel on data privacy? What do we need as a law office to counsel on data privacy? Is this a new practice? Is it related to technology? Is it related to IP? So that's one portion of the panel that we're going to address today, and we're doing that portion through GearSale. Then we're going to get into the hot topics of what is moving in Latin America these days on the privacy issue. For that purpose, Rodrigo is going to speak to us about the new regulation in Brazil, which is real hot topic because it's very recent first. Because of the 600 million people that live in Latin America, 200 million of them live in Brazil, and it's certainly going to impact the whole area. And we're going to try to explain how it relates to the new GDPR, which is a global hot topic, and how are companies and law firms supposed to get prepared to face breaches or security issues on data. And then comes Raymond, with all his experience on cybersecurity in the United States, because of course, they're like very ahead of the Latin American laws and the Latin American situation, in order for him to let us know how should a company get prepared for those moments when privacy gets into trouble. I mean, when there's a data breach, when there's a security problem, what type of data should be protected, in when should we be absolutely preoccupied and get hands-on, whatever happened, and when is it controllable, and what should we do? So that's the format that our panel is having today, and we're going to try to keep it conversational. So if we drop into one another's what they were explaining, maybe our presentation will be a little bit questions may be answered before what we planned, but the idea is to have it nice and to have you have a good time and connect with this privacy topic. So our presenters today, Dirceu Santa Rosa, he works with Montauri Pimienta Machado and Vieira de Melo, and Vieira de Melo.
Vieira de
Melo. Thank you.
But no need to worry, it's difficult to pronounce.
Rodrigo worked with Silverio and Ray worked with Kilpatrick, and I'm showing you, why is it not showing the presentation? Because I want their CVs to show here.
Technical issue. Yes.
Here
Thank
you go.
you.
Thank you. We should be very honored and privileged to have this panel with. This is Dirceu, Rodrigo, and Raymond. So getting into the topic, I think, and I guess that we will start with the law firm capability. So Dirceu, the new GDPR is opening a new window and new opportunities for the legal market. How do you see that moving in Latin America?
First of all, thank you very much, Juanita. Thanks for the invitation from Azipi. And thank you everyone for being here. I know it's the last day of the event, and last night probably really nice, as I heard. So I thank you all for being here, and it's great to have you guys around. A very simple answer to your question is yes. There are several new opportunities that you can see in the Latin America legal market if you consider data privacy. Say, for example, I would use that if we were having the same conversation last year in Brazil about the same time, it was even hard to believe that we're going to have our law is actually going to pass. So with efforts such as the GDPR and this subsequently meant that laws, for example, in countries as Brazil, legal developments started to move forward. In other countries such as Argentina, there are changes and developments. I'm not sure about, for example, your country, which I'm assuming is as well considering changes in their law to adapt to this new international framework that's proposed with the GDPR. But I definitely believe that there are opportunities coming up in the market for law firms, and even for law firms which are from an IP perspective, which is where we all come from. And we have to be honest, most of us as law firms most of our firms were probably in the beginning of the internet domain name dispute. We were right at the beginning of everything when it comes to this type of technology issues. For example, us being patent lawyers, lawyers that were always deeply connected with technology, and technology was part of our day-to-day business. We were natural movers to be in the forefront of some internet legal issues. Napster, copyright infringement, you name it, domain name dispute. Rodrigo knows because he's a panelist at Piper, right? We do have a lot in common with this type of practice, which makes I believe, which makes it a natural move that firms with IP capabilities. I'm not saying that you have to be an IP firm. I mean, firms with IP capabilities would be natural movers in Latin America to occupy space and to be able to better serve clients with technology issues, which include data privacy and data protection.
Mainly because I guess technology is fed with data, and we need to know how would we legally feed that technology with a proper use of
You're
data.
definitely right. Yes, I believe we're definitely natural movers, and that could mean a window of opportunity.
How do you think that a law firm should prepare to do this? What should the people that are working in that field get trainings in? How should a law firm do that move?
Well, I can tell you from my experience. Started my career as an IP lawyer. I still consider myself an IP lawyer, even though I'm more like in the tech space right now. But I still have my roots as an IP lawyer. I went to law school in GW, it's a pet law. So we're all. I'm very keen of my origins as an IP lawyer. But I must admit that well, at times you change. For example, the question is what we need to know to build a data privacy practice. First of all, I believe you need to have a close and good examination on how your market in your particular country, if you're talking about Latin America, in case of Raymond is different because the U.S. has a very mature market, right? I mean, we're in some countries here in Latin America, this market is still in its early ages. So you have to have at least a good idea on what type of clients what are the issues that your clients are going to face. For example, if your country, let's say, your country already has a regulator or a data protection authority, you're going to have to work with regulatory issues a lot. Or, for example, if in your country it's possible that the regulator will handle a breach with a big monetary fine, or you're going to have penalties and such, that require you to have even work together with prosecutors, litigators, and there's also another market that's interesting, which is the market of consulting. But this market is kind of tricky for law firms because in the consulting area, we law firms have to compete with big 5 audit companies, tech consultants, which provide technical solutions for identifying possible breaches and doing what we call data protection impact assessments, the DPIAs. But again, about building your a data practice within the firm, you have to, first of all, figure out whether you have the capabilities internally, whether you have associates or partners which are, first of all, interested in learning, because we're, at least for now in Brazil, we're in a very early stage. So everybody is pretty much learning the tricks and trades of the business. We don't have a business yet. So, but for countries in which this is more mature, you just have to figure out whether you have the right capabilities. And if you do not have the right capabilities, you just have to build them up.
And how do you?
Yeah, Dirceu, do you think this is necessarily a multidisciplinary topic? Let me rephrase it. A law firm, do you think that they may deliver a full solution for compliance with in data privacy law, or do we need to work together with the other kind of profession?
You have both options. I would say that if a law firm can build up this multidisciplinary practice, is great because, for example, data privacy, and here in Brazil we have very stringent local labor laws. We have issues that involve labor law here in Brazil that work with data privacy. We, from my perspective, you can work with compliance. We can work with specialists or other firms that handle these issues as well. And but as you mentioned, Rodrigo, it is a multidisciplinary practice, yes, but there's still a very unique level of specialization, particularly when it comes to handle with regulatory matters. Right now, we don't have a regulatory body here in Brazil yet. The law passed, but still vacant. So we're just hoping to see what's going to happen in a few years. But I'm assuming, for example, I know, for example, in the U.S., Raymond's example, it's a mature market. You already have regulators. You have HIPAA, specific sector-based laws. So you already have a whole body of a whole structure that you can navigate through. In certain countries, you don't have that yet. So,
And I think that would lead us to the next question.
Can I just add one thing? Just real quickly, if you're thinking about entering into the market, the law firm, could even take one step further back and say, law firms as leaders in the industry, the law firm itself has to take steps to protect its own data. As we've seen with the law firm, the Mossack Fonseca firm in Panama, and what happened there, you have to be able to protect your own data because law firms are a treasure trove of data and information. And if you're not able to properly protect your own data, how are you going to go out and try to advise
right.
your client to protect their data?
That's
So
a great point.
That's a fantastic point because then it means that law firms should look at privacy as applying it to themselves as well as offering it as a service to the client because they have a very, very important type of information in their own.
Absolutely. I mean, I think it's probably easier to remove the boundaries of categories of businesses and just look at it in terms of electronic data that's worth protecting. So whether you're a law firm or you're a defense contractor or whatever it may be, if you have the type of information in electronic form that needs to remain confidential and that somebody else may want to see and have or could gain value from that information, then it doesn't really matter what business you're in, you need to find a way to protect. Now, in the US, it's industry-based in terms of, if you're a public company, the Securities Exchange Commission has various requirements. You're, whatever industry you're in, if you're in the health industry, there are different standards and regulations that govern. But irrespective of that, as a law firm, because you have very sensitive data, if I'm a hacker, rather than trying to go to and get into a single company to get information from that single entity, why not go to your firm where you represent a number of companies and you are the gateway for me to access all kinds of information? So it's just something, if you're entering into that space, then you need to be in a position where you could say and present to your client, yes, your data, first of all, is protected with us. Here are the measures we take. Now, here's how we could help you.
Because with data breach comes, of course, this huge reputational issue. I mean, how does a law firm look if they get hacked? It's very complicated.
It is, and I've represented law firms, and it's a very complicated issue. It's a multifaceted approach when you're dealing with something like this. There's the PR angle, there's the notification aspect of it, and then there's the dealing with your clients, existing clients, and then future clients. And so, in certain markets, clients will actually, in the U.S., will want to know about your practices before they're engaged, or they may require that, at least for their data, that you take certain measures protecting their data. So it's just part of everyday practice.
How do you see, Giselle, that Latin American law firms are seizing these opportunities?
Well, within the last couple of years. But several of us participate in international events and discussions which involve privacy. We have seen a growth in the, I believe, at least not in, I wouldn't say not in. For example, we're seeing a growth of interest in Brazil. It's just happened right now within maybe the last 2 years, and the growth here has been exponential. We can definitely see that in other countries. I would say even countries which have a mature legislation in Latin America, such as Argentina and Uruguay, I believe that, as far as I'm aware of, I've been hearing good things about their practices booming. Another thing that's interesting is that just because we had incidents such as the Cambridge Analytica incident, and as Raymond mentioned, situations of data breach and situations in which companies are not keeping their data safe, because right now it's no longer a matter of if, it's a matter of when your data may be breached or compromised. So you already have to have safety precaution measures. Compliance needs to be working with that, and so this this, in a certain perspective, this helped creating a market for Latin American as well, because we cannot expect that certain types of attacks are only going to occur in the Europe or in the US. There is confidential and very interesting information also in service in Latin American companies in Latin America. So if it's easy to access, it's easy to get.
Yes, and specifically because Latin America is a very propitious territory to render certain types of services, like,
Yes.
for example, BPOs, call centers, and the like.
Yes, you're very right. I mean, there is still, as far as I recall, remember several outsourcing deals that happened to occur with Argentina. One of the reasons that they adapted their data privacy law very quickly to be on the privacy shield with Europe. One of the issues was because they wanted to be able to serve European companies in terms of getting outsourcing, BPO services, and that's one of the reasons in which some Latin American markets were quicker in adapting the data privacy law. Brazil was a complicated case, but I can tell you that here in Brazil, we have, at least from our local perspective, we have a significant number of data subjects, which are parties that would be subject to this types of issues. So now we understand that our internal market can be big enough to keep us busy in terms of legal work. And that's what we hope as lawyers, and that's what we hope will happen also. We'll expand into Latin America as well.
Fantastic. And talking about this new regulation in Brazil and the new regulation in the GDPR, I think that Rodrigo wants to talk about how does the Brazilian law relate to GDPR? What are the similarities? What are the differences? Are we talking about like a mirror law here in Latin America? How do you see the regulation all throughout Latin America? Because then we're going to speak about the differences between the United States and the GDPR and how complex it is.
As you mentioned, we have a brand new regulation on data privacy, and it's clearly part of the GDPR. For those who are not used to the data privacy issues, GDPR is the General Data Protection Regulation that just entered force in Europe, European Union this year, this May. And here in Brazil, we have discussed a bill on data privacy protection, I'd say
Almost 10 years.
a decade ago, yeah, from
Yeah.
the last decade. And it looked to us that it would never came up. And then GDPR came up, and 2 or 3 months later, had our law. So final text of our law is directly impacted, influenced by the provisions of the GDPR, and there are plenty of similarities. For example, the notion of personal data is as broad as GDPR, any data that relates to a person that is identified or identifiable. The data subject rights, for example, transparency, access to the data, to his data, the possibility also to have a portability of data from one company to another one, the right to obtain a rectification on information about that subject. All those rights are both GDPR on the Brazilian law. But there are also some different. Those probably are the most interesting part for the ones that are working in this field, because there are very local peculiarities. And one of that is fine. The fine that is applicable for the ones that are not compliant with the law. Here we have a fine that is up to 2%, 2% of the gross income. CPR, we talk about 4%. The deadline also for
4% of the global income.
the global. Yeah, here it's the same. And also, both laws provides a duty of notifying data breach. So we'll talk about data breach later on with Raymond. But here, we don't have such a specific deadline for informing the data breach. The law talks about a reasonable time.
A reasonable time.
Yeah, it's an
While
open.
GDPR
Which can
is
be anywhere
hours.
between a week, a
Yeah.
month.
Let's see how it will be
Reasonable.
interpreted.
So we have, so in the United States, there's various notification. So every state, the United States has its own law now in terms of what you're supposed to do when the data that's compromised, what we refer to as notice triggering. There are many breaches that happen. In fact, more breaches happen that you don't hear about because they don't require notification, because the type of data that's been compromised, there's no need to notify. For example, if the information that's compromised is trade secret, there's no real rule that says you have to notify someone that this information has been compromised. But if you have information that involves somebody's personally identifiable information, then those individuals need to be notified that their information has been compromised. Now, in every different state, Wes, there's a different law. So when we're dealing with a data breach, we have to figure out exactly what these states require, when that is. But those laws also have a reasonable time standard in there. And over the years, the various attorney general's offices have that are enforcing these state laws have interpreted and fined companies in terms of what is reasonable and what is not reasonable. There is no real set dead timeline to say, but typically you want to be able to say, within 60 days of knowing that there's in fact been a breach, that you're providing some form of notification. The key question is, though, at what point are you deemed to know that a breach has in fact occurred? Because, and we could talk about this later, but in the process of conducting your investigation, and data breach cases are investigation cases, when you're conducting your investigation, at what point do you know? For instance, I'll give you an example. With a breach and conducting a forensic analysis in terms of what's happened and what type of data has been accessed, and your root system where you categorize information in your files has a certain segregation where certain files have notice triggering information and other files don't. So in the course of the forensic analysis, forensics experts tell you, I could tell you that, for example, that the hackers came into your house. They actually found the office in your house and were able to get into your office. And then they found the cabinet where you store your files in your office. But what I can't tell you is whether they were able to actually open the cabinet and look at those files, or what they did with that cabinet file. So then the question to you is, okay, well, forensics expert, can you tell me more in terms of what they did with this file cabinet? No, I can't really tell you with any conclusive certainty as to what happened. So do you know that the data has been compromised at that point? Do you have a reasonable basis to believe that the data has been compromised at that point? There are various factors that go into that, and when you put the various complications of different laws and regulations that come into play, then you can see how it become very complicated very quickly.
Yeah, the complexity becomes even more evident because of the multiplicity of law. You have sectorial law, then you have state law, and then what each one considers to be reasonable, what type of breach do you want to report. So it's a very complex environment in the United States.
Absolutely. I mean, even if we're dealing, so data doesn't really have borders as we like them. So, and companies store data in various places, and the data that they do have, when we're talking about notice triggering data, the notice triggering data could have data for residents of various places in the world. So at any one given time when we're dealing with with a breach, the notifications may take you to various parts of the world, and you're notifying individuals in Germany and USSR and Russia and wherever it may be that the residents, the information that you have been compromised. You have to let them know, and then you go look at the laws of those various countries.
Juanita, another possible point of comparison, in which we may include the U.S. approach, is the need to nominate a DPO. A DPO is a data protection officer, a person in charge of dealing with data privacy issues within the company and talking with the authorities and as well with data subjects. The GDPR provides for a need of to indicate a DPO, to nominate a DPO in a specific case. If your company core activities is related to data processing, if you process a large amount of sensitive data, if you are a public company, the Brazilian law doesn't differentiate kinds of companies or size, just says that you need to nominate a DPO. What about the North American approach? Is it a very common position on companies of every size to have someone dealing specifically with data privacy?
Yeah, so it depends on the size of the company, but typically you'll have a chief information officer, and you'll also, depending on the company again, you'll also have a chief information security officer. So you have a CISO, a CIO. Those are two very different positions. It's always good to separate those positions because there could be potential conflict what a CIO may want to do and with what a CISO may want to do. So it's a bit different from a DPO as GDPR would have it, but typically companies are structured that way. There are certain regulations that in the U.S. now that require for certain companies to have CISOs in place.
Raymond, what about smaller companies?
So with smaller companies, it's always a challenge, and sometimes there's vulnerability there because they may be spread too thin, may not have specific individuals tasked to deal with those issues. And so typically you see that manifested, the problems with that in terms of when an incident occurs. First of all, I think you can never have a situation where you say, if I have a CISO, I have a CIO, then this is not going to happen to me, because there's no bulletproof, there's no silver bullet. It's just a question of how do you minimize the risk of it happening, right? I mean, as you mentioned, it's not a question of if it's going to happen, it's just a question of when it's going to happen. But that when, you hopefully delay as much as you can. And so having folks in positions such as that could substantially help minimize risks. But even if the event occurs, there are ways to minimize the cost and the severity of the breach as opposed to just trying to prevent the breach in and of itself. So, for example, there's, and interestingly, the time between when the compromise, the breach happens, to when a company actually learns that the breach has occurred could be months. And you would expect that despite, people becoming more aware of this and hearing about it in the news every day, that time should be shortened, but we see over the years that the time continues to be longer in terms of the time when to when it happens. So we've seen situations where 6 months, 7 months, a year has passed, that they just learned that their systems were compromised. But if you have folks in these positions, it helps minimize the time, it helps minimize the risk, but also helps minimize the time, and the time can be a very important factor.
And Juanita, let me just add just one thing to what Rodrigo said, which I believe is another window of opportunity. Here in Brazil, I'm not sure about other Latin American countries, but I understand, for example, in a comparison with Europe, you don't need to have the DPO doesn't have to be an employee of the company. So there might be law firms that would be able to provide what we could call DPO as a service. That should be an opportunity, at least for Brazil, and I believe in other countries might follow the same perspective, which would work for smaller companies that would not be able to afford having a C-level team like a chief privacy officer. For some companies that only require having someone that would be ready to deal with regulatory authorities or deal with how to handle a data breach and do some. For some companies, that's something that can be outsourced, and I believe that would be outsourced. Could be outsourced into a consulting firm, but could also be outsourced to a law firm. And there's an opportunity that would be interesting.
Can it be outsourced outside of Brazil?
I think that I'm trying to guess here, but I think it needs to be a Brazilian citizen, right?
So now there's no.
Yeah, we don't have a law yet.
Yeah, actually, in the EU system, you can also outsource, but there are some risks doing so. Yeah, because there are a lot of responsibilities. This position, you need to really know what is happening with the company. So I've seen here in Brazil some movement in the market to offer this kind of service.
Yes,
but
yes.
I really recommend to take care on assuming such a position on behalf of a company that you are not really informed about
Hire
how
insurance.
things happens. Yeah.
Yeah, we might need insurance.
Have you seen something like that in the United States?
So, not really. One of the things to keep in mind in doing that is if you're serving as a law firm, if you're serving in any such capacity, when an event does occur, does that create a conflict for the law firm to then continue representing the client? So, it may very well be that, whether as a DPO, is it something that the DPO law firm did in the course of its role as a DPO, and how does that create issues? But typically, we try to separate that. And so, again, I haven't seen that, but separation is
What I
something.
have seen in Latin America is that the companies themselves have like layers of seniority. So maybe in the country they have certain type of DPO or chief information officer, and then they have a regional one, and then they have like a global one.
Yeah, so I mean, the development of the DPOs is a fairly new thing with the GDPR. Prior to that, you weren't really seeing that. I think it was more in the makeup was based on a CIO and a CISO type or privacy officer that are employees or on the C-level execs, especially U.S. companies, is what we've seen so far.
Okay. And Brazilian law has granted like a year for companies to comply. So when is the date in which they need to be compliant, and what are they doing in the meantime?
Yeah, as Dirceu said, it's a very hot topic nowadays here. The adequacy time is very short period. We shall note that European Union, GDPR is an upgrade of a regulation that was already there since 1995 as a
And
directive.
even so, for the companies where it was very difficult to get into compliance or try to be at least into a certain level of compliance
And they had
in
2
May
years.
2008.
And they had 2 years for that. And we have 1 year and a half, and we are coming from, as we say here,
zero.
from 8 to 80. You don't have any foundations on this topic. We have some very broad regulations on the civil code, on the consumer law, in specific law for the internet, but it's not a data privacy real statute describing what is necessary for data processing. So the task is hard. What I've seen in the market at this moment is that companies are overcoming the phase in which they were analyzing the impact of the new law, and now they are moving forward to start complying, trying to comply with the new regulation. It involves a series of activities, data mapping, very beginning. Sure, companies here have been collecting data for 20, 30 years without any care on the source of the data, till when this data should be kept. And therefore, at the very beginning, they need to map which data they have. They need to map also the contracts and the regulations that they have nowadays in this field. There is also a necessary step in which they analyze security measures that are used in order to protect this data. The law describes some measures that need to put in practice, and especially to frame each and every data processing activity in one of the 10 hypotheses that the law provides for. The Brazilian law, such as the GDPR, describes the data protection activities that are according to the law, that shall be done. It's not the opposite. The law doesn't only says what cannot be done, but they describe the 10 only alternative hypotheses of data processing that are allowed here in Brazil from February 2020 on.
Which is carnival.
Which is what I'm saying?
Carnival here in Brazil.
Now,
It's gonna be start on carnival.
people talk a lot about consent, but consent is just one of the options. And actually, it's the last one that we use when we are addressing the data privacy compliance, because we try to reduce the scope to the need to go for your client and ask a new opt-in that fits in the new regulation.
And Rodrigo, we have another problem that we still have. We don't have, the law did not pass the data protection authority. So we're pretty much clueless here. The law is going to come up. There are several articles of the law which refer to the national authority or
Yeah,
to
it will come up. I'm
will
sure that
come
it will come up during the way till
We hope that, but we
Now,
don't know the structure. is gonna-
because if not, we will not fit the reasons why we have this law, which is to be able to process data of European citizens and to provide an adequate level of protection and enforcement comparison with GDPR. But agreeing with you, it's a long and hard way, and we are trying to face it. I'm sure that 2019 will be a very busy year.
Very interesting. And in this road of getting ready, because the United States companies are typically professionals, or they should be, in having like their crisis management step. They get ready, they have accountability, they really look forward to when problems come. Do you see the same thing in Latin America?
Yeah, unfortunately not. There is a huge gap on preparing for crisis here in Latin America and in the US, for example. I can talk about Brazil. We are very proud of something that we call jeitinho brasileiro. Maybe you will not understand what it means. It's like a creative way of addressing problems. Uh, when we need to figure out how to solve something, we say, "No, we are very good on jeitinho brasileiro, the Brazilian way," and it brings lots of creativity, but very few preparation, almost no preparation time, and we need to change it, especially for addressing digital crisis. Uh, I'm not here to investigate the reasons of this gap, if we are not so exposed to natural tragedies, if we are too optimistic, or if we are always in crisis, at least in the economic. But the gap is undeniable.
I'd like to try that approach with the California Attorney General's office one day and see what they think.
Yes, that was something, Raymond, I was going to ask you about, because I read California, and you're based in California, right? California passed a specific state law right now regarding privacy, which I believe set the bar higher, right? I mean, for
Yeah, so there's, what's interesting is, and this is something to, I think, to keep an eye out for the coming years, particularly in the next couple of years. So you're seeing a lot of different jurisdictions, Brazil being one, passing laws that are very similar to the GDPR. And so other places are doing the same thing, but each has its own twist and variation to it. And so California has just passed a GDPR-like regulation. It's called the California Consumer Protection Act, and it goes into effect in January of 2020. So it's similar to GDPR, has obviously differences. The opt-in, opt-out is very different. But and it applies to companies with a certain revenue threshold. But at the end of the day, you're seeing different jurisdictions coming out with very similar laws, but yet they could conflict. So what happens then is you have a conflict of laws related issues that arise if a company is doing business both in the U.S. and in Brazil, or in wherever the new regulation, the regulatory country may be, where those laws conflict. And so that's something to keep an eye out for, because it's almost inevitable that these are going to start kind of clashing, and there's going to be, just as we had in the U.S., where you had different states coming up with different laws. I think this is not really all that different, and you're going to have various countries coming up with laws. But again, as we said earlier, data doesn't have boundaries, so it's very artificial to say that this is just the law of one country, and I don't have to worry about the Brazilian law, because that's true. You're going to have clients that have data on Brazilian residents, or they have business in Brazil, and so they need to be concerned about Brazilian law as well.
And even more complex when you come to think about the data centers, because where are data centers located and what law applies to each one of them. So it tends to get very specific.
Yeah, it's no longer just a question of this practice, and we started talking about, are you ready to counsel on data privacy? It's not just a local jurisdictional issue, it's an international issue. So that's why it's very complex.
And do you have in Brazil like a legal requirement of having accountability in the companies?
Yes, accountability is definitely one of the principles of our laws, GDPR. This is a compliance issue at the end of the day, and that's why there are so many different professionals advising and helping the company not only to fit on the regulation, but also to have ways to prove that they done the homework. And specifically on crisis management, the Brazilian statute provides for requires a crisis management plan, or at least recommends it as a way to show that you have addressed the issue as you
Crisis
should. As you should. It involves some level of risk assessment. There are several institutions that every year assess the main risks to business everywhere. Probably the most famous one is the World Economic Forum, which every year publish a study on this topic, and there is always digital risks going up in impact and also in likelihood of happening. You already mentioned that data breach will happen. Yeah. So it's a subject that you definitely need to pay attention when drafting your crisis management plan.
And that takes us to Raven's field directly, because we see that data protection and security and cybersecurity are pretty related. So I don't know if you can talk about a little bit about this, and how do you see that security and privacy bind?
Yeah, so just from a 30,000-foot level, so security and privacy, very different things. Privacy issues are a consequence of a security problem. So if you've had a security, if your system has been compromised, that leads to a potential privacy issue. Yes, you have other privacy issues in terms of how you use the information that you have, and that may be a privacy issue in and of itself in GDPR-related sense and whatnot. But what we're talking about now here is privacy issue because of a breach that happened, or there's some compromise in information. So they're intertwined, but you could also have breaches with no privacy consequences whatsoever. So in fact, if there are a lot of breaches that we handle that have nothing to do, there's no notice triggering data involved. It's IP, it's trade secrets, and it really isn't a privacy issue. It's just a question of dealing with, okay, you have 3 other partners that you're sharing this trade secret data with, and you're collaborating together to develop a new product, and one of your partners' systems has been compromised. That's also compromised the entire information that the 3 partners are collaborating with together. And so what happens at that point? So that's a security issue with no privacy consequence. But you have obviously situations where there is in fact a privacy consequence based on the breach occurring. So that's how those two essentially tie in together.
Very, very interesting. And let's think, like, bring it to practical. What happens when a company realizes they have had a data?
So typically in a typical situation, it's you get a call at 7 in the morning, and the chief financial officer is frantic and says, we just realized, the IT folks just realized there was some anomalous activity on the logs, and we think that we've been breached. In fact, the breach that occurred was very sensitive information that was not public, and we certainly don't want the tax authorities to learn of this information that's now been compromised. The hackers have said that they're going to release the information unless we give them Bitcoin, and we need to do something ASAP right now. And that 7 in the morning call is, for some reason, never fails at that time. So in a typical situation, once you realize that something has happened, you want to obviously lock down the situation in terms of, if there is a breach, identify the breach, bring in your vendor. But in the U.S., the attorney-client privilege is a very important aspect of these type of issues, and so you want to try to protect what's happening. And I'll give you an example. Is if a company is engaging its own IT folk, they say, we think we've been breached, let's go investigate this ourselves. And in the course of running this investigation, the IT folks are sending emails and doing all kinds of things, looking into things. Whatever they're doing, once there is litigation, or if a regulatory body wants to come and investigate and find out what's happened, they're going to be able to get everything that these IT folks were doing, all the emails that they've sent, when the company declared or knew there was a breach. So in the U.S., the way we typically do this is as soon as that there's any issues, they'll contact the law firm. The law firm will then engage a forensics expert. The company will not engage the forensic expert. The forensic expert is brought in by me so that they could assist me in providing legal advice to the company. So that way, everything that the forensics company is doing in the U.S. remains as attorney-client privilege, and nobody gets to see that. So my discussions and the work that they do doesn't go to a regulatory body. And so you want to do that very quickly. You obviously want to, close down the leak or the compromise, and then you want to investigate. How is it that it happened? What's been accessed? How do we know that that's been accessed? And that takes a certain period of time to do, which is why it's very important not to just come out and say, oh yeah, we've been breached. Well, not necessarily. You want to really look into it. I'll give you a quick example where the systems were compromised. But what the hackers had done is they hadn't really accessed the system to access information. What they had done is they would access the company servers to use the servers to mine Litecoin and Bitcoin. That's what they were using for. They had no interest in getting information. So in a situation like that, and they had been doing this for over 8 months, and so in a situation like that, have you really had a breach at that point? Have you had information that's compromised? And so it's really important to conduct a thorough investigation as quickly as possible. You want to meet the reasonable time restraint as well. But doing that through the law firm is the most important aspect of it when that comes to your attention.
And when you have like a data breach that reaches more than one country, then it, I guess, gets even more complex because you have to get to the law of the other country and try to comply each law.
Right. So you're looking at the laws of. So you want to be able to map. Well, hopefully you have a data map before a breach happens, and that's a really important aspect of going into a company in a pre-breach setting, saying, here are the things you should do. The breach is going to ultimately happen. It's just a question of when. But when the breach happens, let's have things set up so we could we could deal with it in an easier fashion. And so if you have a data map where your data map tells you where your data is, what type of data, and of what residents you have data of, then it's a lot easier. But a lot of times you go in, you have all this data, first putting together, okay, this set of data belongs to residents of France. And so then you got to go look at French law and see what is it that we have to do under French law if the data for the French residents has been compromised. So you're doing this globally, depending on the size of the company and the type of data they hold. You're going to have to go through that analysis.
So that may lead companies to have preventive security measures, not only to know what they should do, but have like security measures to avoid or try to avoid a breach from happening. What's the perspective in that?
So it's so there's various regulations that are developing now that within the regulation requires you to conduct have preventative measures in place. So in California, we have and we use the magic word reasonable again, called the reasonable security. The new California Consumer Protection Act requires reasonable security. In California, we've tried to define what reasonable security is, and in 2016, California Attorney General's office provided some definition as to what that is. It's very technical, and so you're going to have folks in your company or in your firm that are able to understand and speak that language to be able to say whether, when you're advising the company from a preventative standpoint, say, do you have these things done? And if so, does that meet the definition of reasonable security? So this practice, this practice of cybersecurity and privacy is I would look at it as it's a legal issue, but it's disguised as an IT problem. In reality, it's much more of a legal issue than an IT issue, because the IT issue manifests itself into the law and what the requirements are. And so, yes, there are various regulations, and you're going to see much more of this as things continue to develop, particularly with passion and the speed that they're developing in now. But you're going to have regulations in various parts and various jurisdictions where they're actually going to require that you take preventative measures. They're going to define what those measures are.
Yeah, the reasonable word is in all across the regulations of different countries in the world.
I don't think we would have jobs but for the word reasonable. So
Typically, when a data breach occurs, how long does it take to actually report either the authorities or the individuals?
So that varies on the type of data and the type of breach and the type of data at issue. So back in 2012, 2013, where you had the Target breach, Target came out and provided notice that that there was a compromise, and then there were subsequent notifications. My philosophy in dealing with a breach is you want to do it once and you want to do it right. You don't want to keep drawing attention by multiple notifications. So take the time to investigate, but do it expeditiously, obviously. But take the time to investigate properly so that you're providing the notification. It's very difficult to say what would be, depending on the compromise in the data at issue.
At this moment, it's interesting to investigate the role of the attorney, because not always, sometimes there are huge reputational facts, crises such as data. And the communication guys sometimes will come up and say, you need to go out and say, my fault, and say sorry. And we are not very trained on that. We call this a confession law. And so, again, it's a multidisciplinary topic, not from the beginning to the data breach. And connecting to the very initial question to Dirceu, anyone that needs to work in this field, I would recommend to have a very open mind for all the aspects involved in the subject.
Yes, I think that the situation of owning the problem poses a difficulty for companies, because first you have to say, yes, I had a breach. Second, you have to say, how am I going to tell everybody that I had a breach? So do you have like recommendations to companies about how to PR, deal with the issue with their PR people, or?
Yeah, so the PR issue is a complex one, because you have to use it properly, and you don't want to make it seem as if you're just trying to minimize the issue. It's a significant issue. It happened. The data that was trusted with your client's company has been compromised. Clients may lose trust, customers their trust, and so. But you do want to engage a PR and address some of the issues before you're obviously coming out, providing that notification. I think less is more information that way. So if you could package it and provide the notification effectively in one go, you're in a much better position than having this on multiple times. But yeah, having a PR certainly helps.
What are the potential issues that you see upcoming in the horizon?
So one of the things we talked about was the various conflicting laws and regulations that are developing, as in Brazil, GDPR, California. I think another thing to keep in mind, and this is yet maybe a bit in the horizon, but there's been tremendous talk and development of the blockchain. A lot of folks are still trying to understand what the blockchain is, but you are now having the cryptocurrencies are all run on blockchain, but blockchain is not limited to cryptocurrencies, and you have what's developing now in smart contracts. And the way that blockchain operates and works, it's very public. Everything about blockchain is public. You have some hybrid blockchain systems where it could be both public and private, but you're seeing a tremendous level of development anywhere you go, any developing companies. You go to Silicon Valley, everybody's talking about the blockchain, how to use the blockchain to develop various services and so using the blockchain, how that comports with privacy is going to be, I think, a bit of a challenge, and nobody's really figured out how that's going to work yet, because the blockchain itself inherently public, not private. And when you're getting into smart contracts and all the information within those smart contracts, for instance, is public information, although the end user may be anonymous, the information itself is public. The question is, well, how are you going to protect that data? And so it's going to be a very interesting challenge, and see how that develops. So that's just something to kind of keep in mind at the horizon.
We already talked about the California Consumer Protection Act, but I don't know if you see any more challenges that you're going to face on bringing that into place.
Yeah, so a lot of the challenges we see is trying to get companies to address the issues. For example, with GDPR, you see a lot of companies that would like to address the outside-facing aspect of compliance and not internal. So as long as if somebody was externally was looking at the company is interested in saying, well, does the outside window, does it look good? So that the protection authorities are looking at this are going to say, okay, they seem compliant. But it's more of a challenge to get to get the companies to say, okay, well, we need to also, in addition to the window dressing, we need to also address the internal components to make sure that there's compliance internally. And that's been somewhat of a challenge to get that. I think it's going to take some legal development, some news-breaking stories, and enforcement-related issues that's going to draw some attention until companies do that.
Do you think that other states are thinking on adopting regulation as this one in California?
Yeah, so there are. So California is usually within the United States leading the way. But Massachusetts is as well, and there's various other states in the U.S. that do that, and it's kind of a one-upmanship, gamesmanship, not a gamesmanship, but one state outdoes the other state. And then you have the regulatory bodies that come into play, and then they put into this, for example, the 72-hour rule that is in the GDPR breach notification. Some regulatory bodies within the Department of Defense had a 72-hour rule where within 72 hours of a breach, you were required to report 13 categories of information. But most companies didn't even log this information to be able to report it not in a month, but within 72 hours. And so I suspect if you were to go to a company now, say, are you able to actually report within 72 hours if a breach occurs? The answer is probably going to be no. They're not what to report, how to report it, or what to do.
Particularly Brazil, you have this problem. We don't have. It's very unusual when you have a case. There's a breach, for example. Just using as an example, what usually happens. Usually, the breach hits the media first, and then the public prosecutors, or maybe right now the public prosecutor from the state of Brasilia is very active. He would come up and send you a report that you have to fill in saying, hey, did you have any customer information available? So even the way being handled now without the law is already too complicated for most companies, even larger companies. We've worked on a recent case in which the company simply had no idea what was actually breached. They said, well, as soon as the logs hit the media, and they were like, well, we know that these logs are from our company, but we cannot tell you exactly which type of information is there. We cannot tell you exactly the amount that has been actually compromised.
Yeah.
And
I think it's really important to try to beat the media to the punch, because you're going to lose control of the narrative in terms of what's told, how it's told. You want to be able to come out first and announce it. You don't want to be notifying customers after it's already come out, because then it just seems like you're doing that because it's come out. You want to be able to come out and do that before the media gets to. That's a very important part of the breach process.
And knowing that data breach will happen, all the Fortune 500 companies, market says, already faced it. So everybody will have an issue like this. This is the time to show that you did the homework, that you cannot avoid it, but you were prepared for it. And as soon as it happens, you put in practice what you could do in order to reduce the impact of the data breach.
And it's a good opportunity for all of us, which are lawyers, working in Latin America with Latin American issues. This is also one thing that's going to be a hot topic. I mean, being able to provide this type of assistance, whether after the breach, before the breach, or well before the breach, in doing preventive measures.
With no jeitinho brasileiro
No jeitinho,
anymore.
please.
So we have a couple of minutes for question and answers, and I don't know if we could put the light on so that we can see you.
We have a question down.
Here.
You can see.
We'll try to see you guys. I mean, that's.
Oh,
I have a question from Gustavo. We have another.
First of all, congratulations for the talk show. It was excellent, very high-level discussion. As Dirceu correctly pointed out, we are still in the beginning of these issues here in Brazil. We are doing the data mappings. We are now preparing the data privacy contract and everything related to that. And I believe that those contracts are going to start to be litigated in 2, 3 years, maybe 4 years. Now we are making the contract, and there will be certain litigation related to those contracts in 4 years. So I have a question to Raymond. Raymond, how is the litigation scenario in the US about data privacy? Do you already have a significant body of case law that already allows you to say how American judges tend to construe and understand these issues?
Yeah, so the litigation in the U.S. Is, depending on the type of breach that happens, you have class action lawsuits. And the class action lawsuits, it could be class action, it could be not, but a lot of times what happens is when you're provided notification, you may get one of two things. You get a filing in court of the actual lawsuit, or the other side may, instead of filing the lawsuit, say, mail you what they're going to file and say, here's a copy of the complaint that we're going to be filing. There's 2 ways to resolve this. You could pay us X and we resolve this, or we file it. That's scenario 1. Scenario 2 is they just go ahead and file it. In some of the cases in the US where it came out that there was a breach, within 2 days, there were multiple filings, different jurisdictions of class action lawsuits. And the lawsuits are alleging a host of things, but if you would break it down, it's A, you were negligent in protecting the data, and the breach should not have happened. B, when you were aware that there was a breach, you didn't effectively handle the breach and provide proper notification, timely notification, and reporting to authorities and things of that sort. So that, from a 30,000-foot level, is how that's developing. And because of the nature of litigation in the United States, where it gets very expensive once you enter a certain phase, typically what happens is there will be, from a procedural standpoint, there will be a motion filed with the court asking the court to dismiss the party that's representing the company. We would file a motion asking the court to dismiss the lawsuit because there are various theories. One of them, for instance, could be that there hasn't really been any harm. It's just the information, but the individuals have not actually suffered economic harm at this point. And so you try to dismiss the lawsuit in that early stage as a motion to dismiss, but if that fails, given the nature of litigation and the cost, before you enter the discovery stage of the litigation, which is very expensive, you try to resolve those cases. And if you could resolve it, great. If not, then down for a very expensive fight.
We're almost running out of time, but I would like each one of you to give the audience 3 takeaways from the situation that we have been discussing. 3 takeaways. Three important things that the audience, you would like the audience to take away home with them.
For someone that is working in Brazil at this moment, it's time to hurry up. Yeah, the time frame is very short. I see a global tendency of, second point is there is a global tendency of revising for the ones that already have had a provision on data protection, a law on data protection, protection. And so I think it's always interesting to check what is happening on your neighborhood. Like here in Latin America, how Argentina will address the revision of their law. And so let's keep open to learn with someone else's experience. And finally, I think come up from the debate today that there are a lot of opportunities for IP. IP is changing, not anymore just feelings. We are moving to many other areas of connection, and definitely data protection is a very hot topic.
Yourself.
I'll try to summarize my 3 takeaways as be as quick as possible. 1, the opportunities are out there. 2, it's possible to get adapted and get ready for the opportunities. So it's all open. I mean, not only the opportunities are out there, but you should be able to grab them. And the third one is that all the knowledge and skills that you need to acquire to start working with data privacy, they are out there. Nothing is hidden. There's no hidden science around this. I mean, everybody should be capable of being able to adapt themselves and become, as well as IP lawyers, having also an expertise in data protection and privacy. So it's out there. All you guys should be able to grab it.
I would say that there's definitely a standard of care that's developed in terms of protecting data. So number 1, you have to be able to advise your clients on preventative measures and protect data. Number 2, you have to be able to advise your clients in terms of what to do when the breach happens, conducting thorough investigations. And 3, you yourself as a law firm have to be in a position that you could better protect your data, so you could show your clients that you're actually protecting your data. So those, I think, are 3 key points.
Well, thank you very much, everybody. On schedule. So that would be it for us today.
We'll be around there if you have any questions.
Thank you.
Abre a cortina do passado, tira a mãe preta do cerrado, bota o recombo no congado. Brasil, pra mim, deixa cantar de novo o trovador, a merencória luz da lua, toda a canção do meu amor. Quero ver essa dona caminhando pelos salões, arrastando o seu vestido rendado.